YMCA education series is free and open to the public, and we encourage you to spread the word and invite the family and friends to participate. We host approximately 8 to 10 of these programs a month, varying in all different topics. This program will last about an hour, and you might find that you have questions during this presentation, which we'll be happy to address at the end of the program. When you have a question for the speaker, simply type it into chat on the screen, and I will relay the question to the speaker at the end of the program. You may also raise your hand and ask a question yourself if the chat button isn't working for you. But I ask that you please keep your questions general and keep them for the end of the presentation. So we make the most of the time allotted today. Thank you again for joining us today. And now I would like to introduce you to Matt Margolis. Matt is the elder law attorney offering planning strategies and important matters to consider for adult children. And Matt is here to talk to you. And I'm going to turn off my camera and give the floor to Matt.
All right, thanks, Anna. So good morning. My name is Matt Margolis. I appreciate the partnership that our law firm has with the Y. I have been doing these talks now on pretty much a monthly basis for the last 4 years, maybe even more than 4 years. So my partner Lauren Weldon and I have a boutique elder law and estate planning practice in downtown Park Ridge. We work with all sorts of individuals. We do powers of attorney documents for 18-year-olds going off to college, which a lot of parents don't necessarily think about or consider, but are, it's a good idea. All the way to working with the young couples who are starting to have kids or buying their first home, or that need to do some estate planning, as well as working with older individuals who might need to update planning that they did in the past, or maybe they never did any planning. And we want to make sure that we get planning done before anybody has any kind of serious long-term care event. And then on the elder law side of our practice, we do a lot of planning related to helping people apply for Medicaid, protecting assets. There's a particular benefit through the VA that we help people with, and really we just our goal is to be a resource for all individuals, but again, especially on that elder law side, being a solid resource for adult children and their parents, because a lot of times they're going through some sort of transition that is the first time it's the first time they're going through it, right? Whether an older individual is bringing a caregiver into the home or moving into some sort of long-term care facility. We kind of pride ourselves on having taking a pretty holistic approach, not just helping families with what we with the services that we provide, but also connecting them to all the other professionals that they can really benefit from meeting with, and who can be very helpful along that journey. So that's us. And then personally, my wife and I live in we're Northbrook residents. We've been here for the last 4.5 years. We've got 2 little kids. Our son will be going into kindergarten in the fall, which we're excited about, and our daughter is 2. So that is me in a nutshell. Today's topic, right? So let's get to it. Today's topic: planning strategies for the caregiving child. If you have attended some of the talks I've given, there is definitely a little bit of overlap. A lot of these topics sort of have similar themes. To some extent, it's like a Venn diagram, right? Some we're with a bunch of different circles that are intersecting, and kind of depending on the different talks that I'm giving, I might bring up the same topic in 3 or 4 different talks, just because some of these areas really cross over into other areas, and if you're like me, hearing the same thing a couple times isn't a bad thing, right? I think it tends to sort of nail down and hammer down that point. Especially if we don't take notes, I feel like hearing things a couple times is always good, right? Kind of puts it a little bit, ingrains it a little bit deeper in our head. So when we talk about planning strategies for the caregiving child. One of the things that, um, I mean, this is ultimately just something that we see quite often, right? And it's not uncommon nowadays where we see a situation where an adult child has really put their life on hold to help take care of an ailing parent, whether it's their mom or dad. And really, let's say an ailing older adult. I mean, it could be mom, dad, it could be their aunt or uncle, it could be taking care of a grandparent, um, you know, and it's overwhelming, right? It's extremely overwhelming for an adult child in these situations, because for a lot of them, it's the first time they're ever going through it, right? And they don't know what to do. There's inevitably this concern of, am I doing am I doing everything the right way? Am I doing everything that I should be doing? Is there something that I'm missing? Um, in most cases, there is this concern that they're not getting all the information that they need, that they're not doing everything the right way. And so for anybody that is in that situation, I just want to say that, you doing your best is good. And to some extent, that's all we can do. Um, Obviously, the more resources we have, the better. But kudos to those adult children that do put their lives on hold, that are able to, care for a parent who's not doing well. There are a lot of adult children that just, they're not equipped for that, right? They're not built that way. They don't have that ability, or they just don't want to, right? I mean, we have to understand that there's people that, would love to help, and they're just not configured that way, right? We said that, but there's also a number of people that just, maybe they could help and they just don't want to, or they're too busy, right? Um, we always have adult children that feel bad that they can't take care of their parents. But in most of those situations, they're busy raising a family, right? They have two or three little kids of their own that they're taking care of. They are working at the same time. Not being able to take care of a parent is something that, I don't think anybody should feel bad for or fault themselves for. Um, you know, I don't think that most adult parents expect us most parents expect us children to kind of put everything on hold and take care of them. But for those that can, it's great. Um, so, one of the first things I really want to talk about, and this is definitely a theme, in most of the talks, but I won't go into tons of detail. If we've got a parent that's starting to not do well, this is really the right time where we need to be considering their estate planning documents. Okay. Um, and, obviously, a parent starting to decline from a physical standpoint is a lot different than a parent declining from a cognitive standpoint, right? Where there's some sort of diagnosis of some form of dementia, where we know that at some point, our mom or dad will not be able to make their own decisions, unfortunately, right? So typically, when we have some sort of diagnosis of dementia, we know that, in an ideal world, it's a slower progression. We know that's not always, people should know that's not always the case. Some forms of dementia progress very quickly. Sometimes it's just the individual. But these are situations where we really need to start thinking about and making sure that their planning is complete. This is not a situation where, mom or dad is starting to fail or decline, and we should just kind of wait and see and take our time. Because I can tell you that, once somebody becomes incapacitated, or incompetent, I should say, once they don't have the ability to make their own decisions anymore, or make financial decisions on their own, then it's too late to put any documents in place. And so, I'm going to say that the most important documents, everybody should have a will or a trust, or a will and a trust. I'm not going to go. We're not here to talk about those documents necessarily today. But I do want to just briefly highlight that those are important, right? We should all have some sort of document that outlines what our wishes are when we pass away, and who gets what and where things go. But really, in these situations, I really want to make sure that we've got powers of attorney in place. In Illinois, we have two types of powers of attorney. We have healthcare and property. Healthcare power of attorney is a legal document where I'm naming somebody to make medical decisions for me in the event that I cannot make my own. This is an important document, right? I want to have somebody in place that I choose to make my decisions. I mean, if I don't have a healthcare power of attorney in place and I become incapacitated, ultimately there's a default for that. There's something called the Healthcare Surrogate Act in Illinois. I'm not going to go into much detail on it other than saying that Illinois has decided that if somebody does not have a healthcare power of attorney, where they have named somebody to make medical decisions for them, that Illinois, based on public policy, they have a backup plan that says these people, if you do not have a healthcare power of attorney and you're incapacitated, these are the people that will step in to make decisions for you. And it kind of lists people in order, obviously not people's names because the state of Illinois does not know everybody's names that we're close to, but spouse, adult child, good friend. I mean, the list goes on. Maybe by default, that would be the same people that we would pick. But I can guarantee you that in a lot of situations, it's not. Sometimes clients don't want to name their spouse. Sometimes clients wouldn't want a particular child of theirs to step in and make healthcare decisions, especially in a situation where maybe they don't have a very good relationship with a child of theirs, or they have a child that's estranged that all of a sudden comes out of the woodwork. And if I'm incapacitated and that estranged child comes in to start making decisions for me because the Healthcare Surrogate Act is kicking in and the doctors don't know any better, we don't. I've now presumably have somebody making decisions for me that may not have any idea what I would want to be done, and who really may not have my best interest in mind, or at least have my wishes in mind. So, yes, there's a backup. I am not advocating that anybody rely on it, though. My 2 cents is that you get this document in place, right? We put this healthcare power of attorney in place. On the healthcare power of attorney, we can name as many people as we want, but it's one person at a time in a particular order, right? So if I can't make my own medical decisions, my wife steps in. If she can't do it for whatever reason, she's deceased, she's incapacitated herself, or she simply resigns. She says, you know what? I don't want to make decisions for him anymore. Then it goes down to the next person, right? And ideally we have at least one successor agent, one backup. I know that not everybody will. I've worked with clients that, listen, they got one person who they can trust. And that's fine. If that's all we have, that's all we have. I always tell clients, the more the merrier. But of course, I'm not advocating that they name Joe, the neighbor, who's a nice guy and mows their lawn every time they're out of town. So, so again, right? So I've got my wife, I've got my mom, my dad, my brother, my sister, right? So I've got this order of people that can step in and make medical decisions for me in the event that I get to a point that I can no longer make my own. Very important document. Then we have a property power of attorney. The property power of attorney is who can step in to make decisions for me with respect to everything that's not healthcare related. Okay, similar to the healthcare power of attorney, though, I can only name one person at a time, but I can name as many people in succession as I'd like. Now, the property power of attorney, when we talk about decisions that are not healthcare related, it's pretty broad. This will be, who can access my checking account, my savings account, my IRA, my 401k, my life insurance policy, my brokerage account with UBS, who can deal with any real estate that I own, who can sign a contract on my behalf, who can file a Medicaid application for me, who can file my tax returns, who can deal with Social Security or Medicare. My property power of attorney basically steps into my shoes and can do anything that I could have done on my behalf. There is no default in Illinois if we don't have a property power of attorney in place and we become incapacitated. So if I become incapacitated or incompetent and I do not have a property power of attorney in place, there's no surrogate act, okay? There's no default, like I just said. And so what will happen is somebody close to me, unless for the sake of this conversation we're having today, this adult child of mine that's taking care of me will likely be the one to hire a lawyer and go to court and file for what's called a guardianship. Okay, some of us are probably familiar with the term guardianship as it relates to young kids, right? Anybody that's put a will together at any point in their life, if they had minor children at the time, you had a discussion with your attorney about who would be their guardian. Well, we have guardians, just like we have guardians for minor children, we have guardians for adults with disabilities or adults that are incapacitated. And so in this type of situation, we'd be looking at, my adult child hiring a lawyer and filing for guardianship. And this is not ideal. Um, let's say in this situation, presumably I would have wanted this adult child to be my power of attorney for property. And so them being my guardian is fine. Even so, we're looking at a process where, again, hiring a lawyer, going to court, we're looking at a couple $1,000s of court costs and attorney's fees, majority attorney's fees, to deal with this, right? Um, Whereas, if we put that power of attorney in place prior, not only do we get to decide who we want to name, right? So we can pick all the people that we would want to step in for us. So number one, we get to choose, right? We're deciding who's going to come in and be our decision maker. Number two, I can't speak for other law offices, but we're looking at a couple $100s for a power of attorney versus a couple $1,000s for a guardianship. And then lastly, when we have a guardianship in place, that guardian has to go into court at least once a year to provide what's called an accounting to the court. So the court knows how that parent's money is being spent. And then if that guardian wants to sell a house or, move them into a nursing home or anything like that, when there's some major decisions that have to be made, there might need to be court approval. So again, guardianships are fine. They work. They're, in my opinion, they're not ideal, right? I think most of us would like to first of all, pick our own decision makers, but also have it set up in a way that's not involved with having to go through the court system and trying to minimize the legal fees involved. I can just presume that most people would agree with that. So powers of attorney, very important. Okay. Obviously extremely important in the context of an individual who's starting to decline from a healthcare standpoint. But just in general, powers of attorney are important for everybody over the age of 18. Okay, just so everybody understands that. Once we all turned 18, we became the only person in the world that could have access to our financial accounts, or signing contracts, or making, in the healthcare context, making medical decisions, right? So these are important documents really for anybody over the age of 18. Another thing we see are situations where, and this will sort of kind of tie into a bigger picture here, but in a lot of cases we have some adult children, and when they put their life on hold to take care of mom or dad, sometimes those adult children, were successful enough in whatever endeavors prior, or maybe their spouse is still working and bringing the breadwinner, and maybe this adult child who's the caregiver was never working and was a stay-at-home parent, or whatever it is. Every situation is different, but I can tell you that in some situations where we have this caregiver child that's really put their life on hold to take care of mom or dad, in some situations they're living with mom or dad, right? They're living in their home, and maybe they never really worked a whole lot. Maybe they've always lived with mom or dad, and now they're just helping take care of them. Maybe they, worked for a little bit, but didn't really save a whole lot. All I'm getting at is that in some of these cases, we see situations where this adult child is really reliant on mom or dad for paying all their bills, right? And so this adult child is having mom or dad pay their phone bill, take care of all the groceries for the two of them or three of them if both parents are around on a weekly basis or monthly basis. These situations get tricky, and we really need to be careful with them, because in any situation where we have an adult child taking care of their mom or dad, my concern always, and this is because of our elder law practice, my concern always is that at some point mom or dad will be too difficult to be cared for in the home. And what if mom or dad needs to move into a long-term care facility, namely a nursing home, and apply for Medicaid at some point, right? What if mom or dad just, it's a combination, right? They can't be cared for at home, but their assets have also started to be depleted and they can't pay for the care. What maybe they had a caregiver that was still helping out at home. But now they really have no money. Maybe the house was their only asset. They have no money and they need to apply for Medicaid now in a nursing home. So when we look at Medicaid, and I'm gonna bounce back to the mom or dad supporting the child financially. Um, when we look at the idea of applying for Medicaid in a nursing home, ultimately there's certain rules, okay? And so if I move into a nursing home and I'm applying for Medicaid because I have very limited assets and I can't pay the $9, $10, $11, $12,000 a month that it costs, the way that I'm eligible for Medicaid, let's just say that if I'm a single person, okay, if I'm a single person applying for Medicaid in the nursing home, I can have no more than $2,000 in my name. Okay, I can't have a house. I can have $2,000 in my name total. That's the combination of checking accounts, savings accounts, money market accounts, cash value of life insurance policies, IRAs, you name it. The total amount of money I can have as a single person is $2,000. From an income standpoint, let's just say I get $2,000 a month from Social Security. I get to keep $30 a month of my income. Okay, I can pay for my Medicare supplement if I have a Medicare supplement. I can pay for my drug plan if I have a drug plan. But then the remainder of my income goes to the nursing home on a monthly basis. But that's my only financial responsibility. So, let's say I pay for my Medicare supplement, I've got a drug plan, I keep $30. My income was $2,000. I mean, not a bad deal. I think most of us would agree that I'm basically paying $1,500 a month to the nursing home that normally costs $10,000, and the state is picking up the rest, right? Because I'm a Medicaid recipient. And then lastly, there's this 5-year look back period. And so what that means is that when I apply for Medicaid, the state wants to see what did Matt do with his assets over the last 5 years. And really, what the state is looking for is, did I give any money away, right? They don't really care if I, bought myself a new car 5 years ago, or if I bought a $2,000 flat screen TV, or if I, took a $15,000 trip to Greece 3 years ago. The state's not concerned about that. The state's not concerned with me spending money on myself. The state will take issues with me giving money away to third parties, right? Did I write my son a check for $5,000? Did I help pay for college for my granddaughter to the tune of $10,000 one semester? These will be looked at as gifts. And the term that Medicaid uses is, they look at these gifts, they call them transfers for less than fair market value, right? You gave something away and you didn't get anything in return that was of equivalent value. And so a situation where I write my son a check for $5,000, or I pay college tuition for my granddaughter for $10,000, I think most of us would agree that those are gifts, right? And Medicaid will take issue with that, and we'll talk about what Medicaid will do. But something people don't necessarily think about would be, let's say I had a car, my car was worth $15,000, but I sold it to my son for $2,000. Well, Medicaid would say that there was a transfer of less than fair market value, of $13,000, right? The difference between the fair market value and what I sold it for. Similar situation if I had a piece of real estate that I, was worth $100,000 and I sold it for $20,000. Same thing. Okay, we cannot within 5 years of applying for Medicaid, these are issues. And we understand, of course, that people, I don't expect people out there to be looking at the Medicaid policy on a daily basis and to, know that, well, if my mom goes to a nursing home 5 years from now, all these things are, we're gonna have an issue with all these things that she did. Most people don't do it. They're not doing it in an effort to skirt the system. Maybe they are, and that's okay. We just have to figure it out, right? We gotta figure out how to fix it. Because when we give anything away, the way that Medicaid, the way the state deals with it is this. So let's say that I gave away $50,000 over the last 5 years. Okay, and it doesn't matter if it was 4 years and 3 months ago or 2 months ago. The way it works is if I gave away $50,000 within the last 5 years combined, and I go to apply for Medicaid today, and today I'm down to $2,000, I'm eligible for Medicaid. What the state will say is the state will say, Matt, you're approved, but we're going to give you a penalty. And the penalty is going to be equivalent to the amount that you gifted over the last 5 years divided by the monthly cost of care at this nursing home. And so if the monthly cost of care is $10,000 a month and I gave away $50,000, Medicaid's going to say, Matt, you have a 5-month penalty. What does that mean? That means I need to figure out a way somehow to pay for the next 5 months out of pocket the private rate of $10,000 a month. And then after that, then Medicaid will kick in and will pay the nursing home. Well, clearly I would be in a pretty tough spot, right? Because if I only have $2,000 in my name, unless by some miracle, I can get that $50,000 back that I gave away, I'm basically having to plead with the nursing home in this situation to say, listen, I will turn over all my Social Security to you over the next 5 months. Are you willing to let me stay here, knowing that after 5 months, you'll get a portion of my Social Security and you'll get paid by the state. These are tough situations to be in. Knock on wood, we haven't had anybody come to us where this has been a problem. In the 6.5 years that my partner and I had our practice, and even the going back 4 years prior to that, when I was at another firm, but I know that those situations arise, and the state is not very forgiving when it comes to those. It really does become a plea to the nursing home to see if they will let that individual stay there, and really have the nursing home take a much smaller amount of money each month for maybe a number of months. When we have a married couple, so if I'm applying for Medicaid and I have a spouse at home, all the numbers we just talked about for me still apply. I can have no more than $2,000 in my name. I get to keep $30 a month of my income. There's the 5-year look back period. Well, my spouse can have $109,560 in his or her name, a house, and there's no, the house can be any value, and a car. Okay, so my spouse can have $109,560, a house and a car. My spouse can also have $2,739 a month of income, $2,739. And so what does this mean? This means that, let's just say my spouse, her Social Security is $1,500 a month, and mine is $2,000. Well, remember, I get to keep $30 a month of my income. I pay for my Medicare supplement. I pay for my drug plan, and let's just say that leaves me with $1,500. And if I was a single individual or widowed individual, I would have to give that $1,500 to the nursing home. Well, in this example where I have a spouse at home, I can transfer my excess income to her to get her up to that $2,739 number. So again, if her monthly income is $1,500 from Social Security, I could transfer $1,239 a month to her. And now my only financial responsibility between my wife and I to the nursing home on a monthly basis is $200 to $300. Okay. In some cases, we've worked with couples where their income combined was low enough where, we had no financial responsibility to the nursing home because their income combined was, either right at $2,739, a little bit below, or even a little bit more, but with the Medicare supplement being able to pay for it, we didn't. The spouse that was at home was able to continue to keep all the income, and so that's always nice in those situations, because most of the time they're very reliant on all that income to make sure that all the monthly expenses are being paid for. And then the 5-year look back period applies to both spouses. Okay? It doesn't matter that I'm the one going to the nursing home. If my wife has bank accounts and she was giving money away and making gifts, that would impact my Medicaid application all the same. All right, so now we're going to go back. Right, I tend to jump around a little bit, but now we're going to go back to that situation where we've got this adult child that's at home and has been pretty reliant on mom or dad, or mom and dad, from a financial standpoint. And so what I get concerned about in these situations, again, are situations where mom or dad maybe was giving son or daughter that was caring for them some sort of an allowance, right? Maybe they were writing them a check on a monthly basis for $1,000 or $2,000. Okay, and then that adult child was using that money to pay for all their expenses. In some cases, maybe they weren't writing them a check, but they were all the groceries on a weekly basis that mom or dad was paying for. Any car loans or student loans or phone bills, those are being paid directly by mom or dad. In situations where mom or dad is paying for all the food, I'm not as concerned in those cases. But when all of the adult child's bills are being paid for, and or a check is being written to that adult child on a monthly basis, this is where we have this issue with the gift, because Medicaid is going to consider that to be a gift, right? Any money that was used to pay, whether it was a check written to that adult child or whether that adult child's bills were being covered by mom or dad, Medicaid will look at those as gifts or transfers for less than fair market value. And those can significantly impact the Medicaid application. And so one of the things that we bring up with clients in these situations all the time is the idea of, why don't we consider the idea of putting together a caregiver contract between, mom and dad and adult child, or mom or dad, whoever it is. But why don't we have a contract between the two of them? And some clients look at that and they think it sounds silly, but, our point is, you're caring, we're not just making this up, right? Of course, we would never do that. But you're already caring for your mom or dad, right? You're taking them to their doctor's appointments. You're taking them to the bank. You're helping them get dressed. You're helping bathe them. You're cooking for them. In some cases, you're even feeding them. I mean, you are their caregiver. There's no problem being reimbursed for that. And to some extent, they're already being reimbursed, right? Because their bills are being paid for by mom or dad, or they're being given that check on a monthly basis. So in these situations, we just, it's best that we just memorialize it, right? Because now we've got an agreement in place, right? And the agreement says, I, the elder, am going to be paying my son or daughter, $15 an hour, or typically, on a daily basis would be easier so that the hours don't have to be computed. But, I'm going to pay my adult son or daughter $100 a day or $150 a day as my caregiver. And now we have a situation where, now that it's in writing and now that we have this caregiver agreement, if we go to apply for Medicaid down the road and any of these payments to the adult child as the caregiver were within 5 years, we can go back and we can say, look, we've got this caregiver agreement, right? This money wasn't just gifted. I didn't just gift this money to my son or my daughter. He or she was taking care of me and providing all these services. And of course, we probably want to have something from the doctor that would state that I, was in a situation where I really needed, where I needed some sort of care to be provided. Because now we won't have an issue with all that money that was transferred. Transferred. It doesn't, but we cannot make a caregiver agreement retroactive. So I can't be the saving grace where, a client comes in and mom or dad's already been giving them money for the last 3 years. I can't tell them that I can go back and we can't backdate a caregiver agreement 3 years. Our goal in those situations, and again, every situation is different depending on who we're working with at the state. A lot of times it's really caseworker by caseworker. But in a lot of those cases, in those situations, the argument that we would make, if the state said, well, anything after August 1st, 2021, we understand, right? You have a written agreement, and so all that money, we would never consider that a gift, but all the money that was given to, Jane, the daughter, prior, is a gift, our goal in that situation would be to advocate for the family and say, let's be reasonable here. Let's put two and two together. Clearly, the same situation was occurring prior. They didn't realize that, the issues that could be involved from a Medicaid standpoint. They came to see us. We helped them with this. This is all the same situation, right? This is not a situation where they were just gifting money, and in those cases, obviously it's ideal if we can go back and get, medical records showing that this individual, maybe already, maybe had a diagnosis of dementia dating back to 2018, or even just if there's nothing in the medical record necessarily, getting something in writing from their doctor saying, listen, this patient has been under my care for the last 20 years. For the last 8 years, I know that they've really needed assistance from a third party. They haven't been able to handle all their activities of daily living. And so, the goal is obviously in that situation, trying to piece things together so that we can try to avoid that gift and that penalty during the Medicaid application. And so, yeah, we're big advocates of the child caregiver contract. Again, if you're paying or supporting that adult child anyway, let's just make it let's use a caregiver contract. Okay, let's minimize the issues that we know we will have. We will have them. I can guarantee it. But let's minimize those issues or avoid them altogether if and when we apply for Medicaid down the road. Last thing we'll talk about is how to, in some situations, how do we protect assets, right? And so, for an adult child that has, put their life on hold and been living with mom or dad for a number of years, it's scary when mom or dad runs out of money and has to go into a nursing home and apply for Medicaid, because as I mentioned, a single individual is not allowed to keep a house. And so if I am a single or widowed individual, even if my adult child has been taking care of me, I move to the nursing home, in most cases, the house will have to be sold. All right, and now my adult child has to look for a place to live. However, in situations where that adult child has been caring for me and living with me for at least 2 years, okay, providing care and living with me, and they cannot have a house somewhere else. Okay, they can't, this can't be a situation where they're like spending the night here and there, or even if they're there 12 hours a day and then going to their own home. Their residence has to be my residence. Okay, but a situation where my adult child has been living with me and taking care of me for at least 2 years prior to the time I leave the house and go to a nursing home and apply for Medicaid, I can transfer ownership of my house to that adult child that's been caring for me. And it's not considered a gift. It's not considered a transfer for less than fair market value. Okay, we call it the child caregiver exemption. Okay, so that adult child has been living with me and taking care of me, I'm going to keep on saying it, for at least 2 years prior to me moving out of the house and applying for Medicaid in the nursing home. I can transfer my house to that adult child. Now, in these situations, we're going to, and this shouldn't be hard if this adult child was actually providing care. This shouldn't be hard. What we ultimately end up needing to prove this to the state is that we're going to need some paperwork or some different documentation, I should say, to provide the state to show that that is that child's address, right? So, phone bills that are mailed to the adult child at that address, a driver's license that shows that address is theirs, tax returns that use that address as theirs. So that type of documentation would be necessary, as well as getting something in writing from mom or dad's doctor that says, listen, this person's been a patient of mine. They have required care. The state is going to want to see something from the doctor that this person has actually required care, right? Because obviously, we can all agree, I could just make it up and say, yeah, I was caring for my mom or dad. Here's all this paper documentation that shows that it's my address too. And so the state's going to require a letter from the doctor saying that, yes, this person's been under my care for so long. They have suffered from X, Y, and Z since this date, and to my knowledge, and they have required assistance from a third party. And even better, if they say, to my knowledge, their adult son or daughter has been their primary caregiver for the last fill in the blank, 2 years, 3 years, 5 years, 6 years. Um, this child caregiver exemption doesn't come up often, but we've had it come up a few times, and it's been great, right? Because we've been able to, protect, rather than having to sell, rather than having to kick the adult child out of the house that has been theirs for the last however many years, and then have to sell it. And if it gets sold, guess what? That money goes to mom or dad, and now they've got to spend all that money on a monthly basis at the nursing home until it runs back out down to $2,000, and then they can get back on Medicaid. So it's a real beneficial route to take in situations where we're able to. Um, the other thing that we want to consider, and I'll just touch on it very briefly, is the idea that if mom or dad is moving into a nursing home, and maybe they still have some funds, right? Maybe they still have some money. They don't sound like somebody has to be down to $2,000 to go into a nursing home, right? That's just what we can have as a single person to apply for Medicaid. Plenty of people go into nursing homes and they've got $100,000 or $200,000 or $600,000. I'm not going to go into any real detail on this because that's a whole other conversation. But these are situations where even at the last minute, people still have the ability. There are ways to protect assets so that if mom's got $300,000 left, we don't have to just necessarily have to spend down $300,000 in the nursing home and then let it run out to apply for Medicaid. Depending on some different circumstances, there's situations where we can protect 50 to 60% of that. At the time that mom's moving into the nursing home. In an ideal world, people are proactive. Okay, so if we've got that adult child that's living with and caring for mom or dad, and they have some assets, and they know that these assets over time will go away and will be depleted. There's planning we can do, right? There's Medicaid has a 5-year look back period, which means that if we're proactive and we do planning, and we don't have a crystal ball, obviously, but if we do planning, ideally 5+ years before our mom or dad ever needs to potentially move into a nursing home and apply for Medicaid, we might have the ability to protect some of their assets, right? There's different vehicles that we can use to sort of set some of their funds aside. Because I would argue, what we see very often in our office is this, parents have this desire to leave something to their children or their grandchildren. While in most cases, not every case, but in most cases, you have the adult children that are saying, hey, mom or dad, you know what, this is your money. We don't need it. Spend it on you. But there are ways that, we can set some money aside. We can protect it, even if it's just a little bit. Grandma or grandpa, whoever, mom or dad wants to leave something to the grandkids, there might be ways where we can do that. But again, obviously we all know this, and this relates to everything in our lives, right? We have, when we are more proactive, we have more options. Right? I mean, nobody's going to disagree that when we have more time on our hands, not more time on our hands, but when we do things, what's the term I'm trying to think of? I just can't think of the word. I guess proactive really is just the word. When we're more proactive and we don't procrastinate, we're able to think more clearly, and we typically have more options, right? When we procrastinate and we're not proactive, a lot of times that's when we are having to act in crisis, right? And now we have less options, and we're not thinking with a clear head, right? Because now there's so much emotion built up in it because we're in the middle of this crisis, that we're not making the best decisions. And so, again, I don't fault people for this, right? I mean, I think that the reality is most people just don't understand. They have the ability to maybe, protect assets, or they just don't have the education to know that, the powers of attorney exist even, right? I know some of us might think that it's so common, but they're not, right? I mean, if you're not looking for these things, they're not obvious. And so, obviously we do our best to educate people, but, our goal is obviously for everybody to be more proactive, to get these things done, at least to ask questions, to start getting, seeking information, even if they don't necessarily act, get the information and understand what your options are. so at least you have the uh, artillery, if you will, to be able to make a more informed decision. Um, 10:08. I know we've got a couple minutes left, but I think that's about it. I think that's about all I have for today. And I'm happy to. I know we've got one person attending. So if you have any questions, I'm happy to entertain any questions you have here.
Thank you so much, Matt. Um, do you have questions? I'm not sure who that is joined, but if you have any questions, feel free to type them in the chat or raise your hand.
Going once, going twice.
All right. Well, this concludes our YMCA Education Series presentation. On behalf of the North Suburban YMCA and our guest series, we thank you for supporting our organization and programs like this. Special thank you to Matt Margolis for speaking with us today and reminding us to be proactive and kind of thinking ahead. Programs like this one are free and open to everyone in our community. So if you enjoyed today's program and would like to support North Suburban YMCA, please consider helping with the donation at nsymca.org. We hope to see you at our next speaker series tomorrow, Thursday, August 5th at 11 o'clock, and the topic will be the journey to financial success. Thank you again and have a wonderful day.
Thank you. Have a great day.